Great. I think most people probably had the possibility to join by now, so apologies for my voice. We'll start with our webinar, From Judgments to Justice, Human Rights Bodies versus Impunity for Crimes Against Journalists. My name's Wiebke. I'm a legal officer at Media Defense, and I'm joined here today by 4 experts from different regions across the world for an hour and a half where we'll discuss this topic. So welcome to all of you, and I hope we'll have fruitful discussions. We'll have a short Q&A session at the end of our session. So just as a little housekeeping, there's a Q&A section on the bottom of your screen. So feel free to drop your questions either now or after the discussion. We'll collect everything and hopefully we'll have the chance to ask as many questions as possible. So today's webinar is held in the context of the Day to End Impunity for Crimes Against Journalists, which took place yesterday on the 2nd of November. This day was proclaimed by the UN in 2013, but remains as important as ever. According to UN data, 162 journalists have been killed in line of duty between 2023 and 2024. And about 80% of those journalist killings, since 2006 remain unsolved, meaning they're either not properly or at all investigated, and that perpetrators are not being brought to justice. Beyond killings, which is the most extreme form of violence, journalists around the globe experience other types of attacks, including enforced disappearances, arbitrary detention, torture, assaults, threats and harassment, both online and offline, for carrying out their journalistic work and reporting on topics such as corruption, human rights abuses, environmental crimes, and other topics of public interest. Such attacks violate the rights of journalists, often lead to self-censorship, and have a chilling effect on society. So the aim of today's webinar in the context of this important day is to facilitate cross-regional dialogue and strategize collaboratively to counter impunity for such crimes against journalists and enhance journalistic protection through courts. We're joined today, as I said, by 4 experienced lawyers and human rights defenders from across the world who will speak to us about the challenges they encounter in fighting impunity and bringing cases of crimes against journalists to courts to achieve justice and also implement other measures to counter impunity for these crimes. So I would first like to welcome Tsema von Ede. She is a human rights lawyer practicing in Nigeria with experience in governance, grant making, program management, and gender. She's worked with a variety of stakeholders on the implementation of people-centered policies to protect citizens' rights, and she has founded a law firm where she worked as a litigation lawyer on pro bono work regarding access to justice. Tsema has experience in actively strengthening grassroots activists to document and expose human rights abuses, as well as conducting community outreach and mobilization. Second, I would like to introduce you to Yi or Dan Hoang. Dan is the executive director of Viet, a pro-democracy political party in Vietnam. Previously, he's worked as an investment banker with a focus on East Asia. And after having left Vietnam at the age of 3, during his frequent trips back to Vietnam, he's witnessed the dynamics of the people, but also the need for democracy to harness the country's full potential. Dan has testified before US congressional committees on human rights issues and has written for the Wall Street Journal, The Diplomat, Asia Times Online, and leading Vietnamese language publications. Our third panelist is Furkat TISHAEV. Furkat is the interim law and advocacy officer at the European Implementation Network, which works on the implementation of European court judgments. Furkat has previously worked in the human rights field in various capacities, including as an advisor to the Council of Europe Commissioner for Human Rights, a legal director for with the Stitching Russian Justice Initiative, a senior lawyer for the Memorial Human Rights Center, and as a lecturer on human rights at the Higher School of Economics in Moscow. And then last but certainly not least, we're joined by Carlos Domínguez Hernández, who holds a law degree from the National Autonomous University of Mexico. He specializes in criminal law, constitutional law, human rights, and anti-corruption, and has worked in public institutions, human rights organizations, and law firms focused on criminal and constitutional litigation. Carlos currently serves as a litigation lawyer at Propuesta Cívica in Mexico, where he's representing cases of human rights violations against journalists and human rights defenders. To start off, we will hear short interventions from each of our panelists about the different contexts they operate in. They will tell us about the types of risks faced by journalists and human rights defenders in the respective countries or regions, and about the regional and international systems available to them to counter impunity for those crimes. I first hand the floor to Carlos. Carlos, please. I think you have a presentation, so.
Okay. My presentation. Hello, well, my name is Carlos Domínguez. I am a litigation lawyer at Propuesta Cívica. I want to thank Media Defense for the invitation. It's an honor to be here with us and my colleagues. Well, today I'm going to talk about 4 things. First one is who we are. Second, our experience. Third, on study cases, and 4 international cases. Well, who we are? We are Propuesta Cívica. It's a Mexican organization founded in 2011 with the mission of contributing to the defense and promotion of human rights and freedom of expression in Mexico through the comprehensive support of human rights defenders and journalists at risk because of their work, as well as advocacy in public policy, applied research, and human rights issues. Our experience. From our experience handling serious human rights violations against journalists in Mexico, we encountered numerous challenges, most notably the high level of impunity for crimes committed against them. Although Mexico has a National Special Prosecutor Office for Crimes Against Freedom of Expression, sadly, even though its existence by itself does not guarantee justice, accountability, or truth. Study cases. Cases of murdered journalists such as Mirolava Bridge, Javier Valdez, Miguel Ángel López Velasco, his wife and son Yolanda de la Cruz, Gustavo Sánchez Cabrera, Regina Martinez, and Julio Valdiva exemplify systematic failures. For example, the lack of due diligence in investigation, the involvement of organized crime, absence of conviction for intellectual authors, and the tolerance and negligence of the Mexican state. Only 2 of these cases have ended in conviction, none against who ordered the crimes. While in those cases the courts acknowledged the journalist's work as the reason for their kills. When it comes to the disappearance of journalists, the situation is even worse, 100 of impunity. Not a single case has led to a conviction in domestic courts. Most an investigation are not even officially recognized and enforced disappearance. Since 2022, only 1 case has been registered by the FEADLE as disappearance by private individuals. Meanwhile, the rest have been classified under other categories. International cases. As a part of our strategic litigation, and after observing no advantage of national instance, in 2022, we submit 2 individual communications at the United Nations Human Rights Committee concerning the cases of Mauricio Estrada Zamora and Ramon Ángeles Salva, both about disappearance, due to Mexico's failure to ensure justice in those investigations. We chose the UN human rights system instead of the Inter-American system because of the latest case backlog and excessive processing times, sometimes 20 years or more, which will be only prolong the family's long wait and uncertainty. International cases. After 3 years, the Mexican state has finally submitted its response in both cases, arguing that the investigation remains open, that there is no evidence of direct state involvement, and the domestic remedies have not been exhausted. However, more than 10 years have been passed in each case without a single substantial lead or piece evidence clarifying the truth. In one case, we have already filed the rejoinder to the state response, and it's now procedurally ready for review and resolution for the second case. Challenge. In this disappearance case, the prospect of obtaining conviction is virtually impossible, given the lack of progress, the absence of research and investigation plans, and the loss of key evidence due to the state's failure to act with timeless and started due diligence. This ongoing negligence prevents victim families from obtaining full reparation and justice. Well, for future, we believe that international investigation does not replace national justice mechanisms, but it does serve to expose the state to responsibility and to pressure the Mexican government to comply with international human rights obligations, mainly regarding freedom of expression and crimes against journalists. Thank you.
Thank you so much, Carlos. It's really interesting what you've been telling us about the state of, or the risks that journalists are facing in Mexico when conducting their legitimate public interest reporting. And I think one point that's really interesting that you mentioned is the combination of international litigation, but also national pressure and national initiatives. So maybe this is something we can talk about later on in the discussion. But now I would like to hand the floor to Tsema. Tsema, please.
Thank you, Wiebke. So I want to start with a little bit of a background. I will be speaking about the African regional rights system, African regional system. Then I'll narrow it down to the ECOWAS court as we continue our conversation. And just to put it into context for people who might not be too familiar with the law and the provisions within the law that protect journalists, we have Article 19 of the Universal Declaration of Human Rights. We have Article 19 of the International Covenant on Civil and Political Rights. We also have Article 9 on the African Charter on Human and People's Rights. We have, in Africa, we also have the Declaration of Principles on Freedom of Expression and Access to Information. There's a UN Plan of Action on the Safety of Journalists and the issue of impunity. And it provides a comprehensive framework for preventing, protecting, and prosecuting crimes against journalists. And there's another one in Africa called the African Digital Platform on Promoting Journalism and the Safety of Journalists. And it monitors and reports attacks in real time. And so you wonder, with all these frameworks internationally and regionally, why is there still impunity against journalists? How do states get away with violence against journalists? And I think it's not necessarily states, but even individuals, it's because states have failed in their obligation to protect, promote, prevent, and investigate crimes against journalists, so to speak, especially when it's their rights, especially in the exercise of their journalistic duties. And how states have also found a way to impugn on free speech and freedom of the press. They've used local laws. So we now have national legislations like cybercrime and anti-terrorism laws, criminal defamation laws, state secret laws. They use all these kinds of creative ways to continue to impugn on the rights of journalists. And so sometimes, in some cases, when violence against journalists is perpetrated, there is an excuse that, well, they deserved it, or they were being defamatory in their articles and related talk like that. So how do we ensure that these things do not happen? Because we see it happen across the region, from using criminal defamation laws to arrest, using slaps to arrest and violate journalists' rights to fake news, and using cybercrimes and fake news, as they would like to call it. And so we have a problem, and it's not peculiar to Africa. It spreads across the world, but I'm honing down on Africa, right? And so take, for instance, in Nigeria, we have the Cyber Crimes Act. We have in Kenya, we have the Computer Misuse and Cyber Crimes Act. In Tanzania, we have the Cyber Crimes Act. In Zimbabwe, there's the Patriot Act. In Burundi, there was a journalist that was sentenced to 10 years in prison under a law criminalizing, according to them, it undermines the integrity of the national territory. And so this is a problem. So for instance, when I was in Nigeria, there was a journalist who was arrested for doing an expository on corruption in the government, in the state government, and they used the Cyber Crimes Act to arrest him. First of all, he was forcefully disappeared. They kidnapped him. His name is Daniel Ojukwu. First of all, he was forcefully disappeared. It was his agency that kept announcing. I think after a week, he hadn't been found. His family was looking for him everywhere. Then we found that it was the police that had him. When we found out it was the police that had him, they said they were arresting him under the Cyber Crimes Act, and they had a right to keep him without placing any charges against him for 1 week. It was just going through certain levels of violence, and his rights were impugned upon, so to speak, until advocacy began and there was noise made about it. And it also happened with Florian Irangabiye in Burundi. But what made her different was that they did not even, it wasn't even a case of this law was just preposterous, but there was even no justice, to the sense that they didn't go back and say, oh no, the conviction was not necessarily repealed upon appeal. What had happened was the new president came and granted her pardon. And so it makes us think that if you're pardoning her for something that we don't even consider a crime, what are states doing? It's almost like states don't understand their obligations, and they don't understand their positive obligation to take all reasonable measures to prevent, investigate, and punish human rights violations. How do we make this thing stop? We have to first of all recognize that there is a problem. And I think the thing is that journalists don't speak about it well enough, maybe because their organizations or their whatever entity they are representing does not look out for them or do not say they need to speak to it. In the course of my work, I've had journalists who have been harassed, intimidated, arrested, beaten up. And when you go to them and you ask them, what is your boss doing about it? What is your agency doing about it? Sometimes their bosses even kill the stories that they put out there that put them in trouble, quote and unquote, trouble in the first place. Or sometimes their agencies don't even want to get involved. Sometimes they're reaching out to you that their cameras were broken while they were covering protests, or they were attacked while they were covering elections, and there's nothing that is done to them. And so we even understand that while states have a duty, the state is failing in its obligation, and that's what causes impunity to thrive. And so we have to push back against that. We've tried to use the ECOWAS court, and the ECOWAS court has, within the region anyway, the ECOWAS court has tried to look into this matter and has tried to also again and again emphasize that the state has a duty to the state has a duty to prevent, protect, and fulfill. What's the third one? Investigate crimes against journalists. A case that comes to mind in the ECOWAS court is Dada Haidara versus the Gambia. Dada Haidara Jr. is the son of a journalist, Haidara. Journalist's name was Dada Haidara, who was killed in the court. He was basically assassinated in the course of his work as a journalist. And his family had brought a lawsuit against the state of Gambia in the ECOWAS court, saying that, and in future conversations, I'll speak about the ECOWAS court, its jurisdiction, and everything like that. But what had happened was Dada Haidara's family came forward and said that the state failed to conduct a proper and effective investigation into the murder of this journalist, and the state violated its duty to protect him. I think that's the thing. A lot of times states forget that they have an obligation to protect journalists. And it's often because journalists do stories that expose corruption, expose, for want of a better word, their bad behavior. And so they do not want to interrogate these cases because they feel it's okay. Good thing that journalist has been silenced. But us as citizens, us as lawyers, I think it's our obligation to ensure that the state does its job. Anyway, the ECOWAS Community Court of Justice ruled that the state's failure to act is a violation of its human rights obligations and incited the ECOWAS Treaty and the African Charter. And the court found that the Gambia had violated its treaty obligations and ordered it to pay compensation to Haidara's family and for legal costs. Maybe as conversations go on, Wiebke will speak to how sometimes the states even fulfill these obligations or these mandates given to them by the ECOWAS court. To what extent do they obey the regulations given to them by the ECOWAS court? And if they do, what do they do about it? We still have all those conversations that come in and come out when it comes to protecting journalists. But at the heart of the matter is the fact that I think what I want us to end with this session, from my own end, what I would like for us to end with from this session is to emphasize the fact that while states are failing in their duty to investigate, prosecute, and I keep forgetting the third one, protect, while they are failing in their duty, it's very important that us as citizens hold the state accountable. And let's not act like it's not our business, because a lot of times they're like, oh, it doesn't concern me, I'll mind my business, and all of that. But I feel like as long as we do what we need to do to protect journalists, but we really need to understand that the violence against journalists is at the core of what we do in a democracy or for whatever it is. And if we allow injustice against journalists to continue to thrive, then we have a problem with ensuring that we have good governance and democracy. I speak from an African perspective. I've seen where in Africa, holding these leaders accountable via free press is what has helped a lot of communities, it has helped a lot of people, and even lifted people out of poverty. And again, remember, human rights are interdependent and interconnected, right? And so when you think, oh, this right is just freedom of expression, it's just a journalist right, free press. And there's something that blows my mind. I hear people say it all the time. Where your rights begin or where your rights stop is where my rights begin. There's a responsibility that comes with your freedom of expression. And so how you say things depends on how people react to it. I do not agree with that. I feel like everybody has a right. I do not feel that is what the law says. Everybody has a right to express themselves. You have a right to hold an opinion. Now, what you do with my expression is totally up to you, in the sense that you also have a right to express yourself, as opposed to deciding that you want to use violence against this person, that is a problem. And so when you violate someone's right to expression, you violated someone's right to freedom in some cases, you violated someone's right to privacy, someone's right to dignity, and you find that different rights start to be impugned upon. And that is why we cannot look away from it. Oh, just one journalist, a noisy journalist is problematic anyway. You let him get arrested, you let him get killed, his family did not get justice, and we are okay with it. And the next thing is they are doing something else. You have no access to healthcare, you have no access to good governance, you have no access to a wide range of things that your rights that the state should actually fulfill. And so I want to end it. My final ending is to say that we must remember that rights are interconnected and interdependent, and it is important that we ensure the protection of journalists' rights to expression and free press to protect our own rights as a community, as a society, and the world at large. Thank you very much.
Thank you so much, Tsema. And I think I saw some of the panelists nodding in the background. I think you really outlined very well the divergence between what international treaties or regional treaties outline and mandate, and then the reality on the ground, which is also something we've seen in Carlos's presentation. And handing over to Dan, I think you'll speak to us about the context in Vietnam, which is dire in similar ways. Thank you, Dan.
Sure. Thank you, Wiebke, and thank you, Media Defense, for putting on this webinar today. We can go, to the slideshow. So we go to the next slide. So, we're meeting on the occasion of the International Day in Impunity Against Journalists. So I just wanted to note some of the bloggers and journalists currently imprisoned in Vietnam arbitrarily. I think Media Defense has worked on a number of these cases of the folks we see on the screen today. And I think it's really important to raise the injustice of these arrests, but also to honor and celebrate the issues and causes that these very brave individuals have raised, because I think ultimately it's really important to amplify their voices, and that's one of the ways we can end the impunity. So if you go to the next slide, I just wanted to take a step back and talk about how there's this systemic impunity in Vietnam, and I think it stems from a number of factors. The first is there's a state monopoly on media. So there's hundreds of newspapers, radio channels, TV channels in Vietnam, and they're all owned by and operated by either the government or the Communist Party. So that's the first step in terms of like this control and hence the repression against independent voices. Thankfully, with the internet, with social media, there's been a flowering of expression online, and that's where you have the de facto free media in Vietnam. But over the years, the Vietnamese authorities have found ways to censor social media, and more they're working with the big tech companies, specifically Meta and Google, to comply with their request to take down content for allegedly violating local law. And the government has these what they call opinion shapers or bots that actually report against pages of normal Facebook users and accuse them of various abuses, and those pages are taken down for violating the standards or copyrights on YouTube or Facebook. So that's kind of the second area where the government is trying to limit the online expression. And I think third is frankly criminalizing free expression. So there's a very long penal code in Vietnam, and particularly there are 3 articles used by the authorities to silence expression. So the one that we hear the most is Article 117, which considers criticisms of the state or the Communist Party as propaganda. So so if you conduct propaganda against the socialist state, that could land you in jail for maybe 20 years. So that's the one that's used the most against bloggers, but there's also 2 other ones that are worth noting. If your expression is deemed a little bit more dangerous, a little bit more organized, then the authorities will use Article 109, which is attempting to overthrow the People's Administration or having activities aimed at overthrowing the People's Administration. But essentially, it's just exercising freedom of expression, freedom of assembly. And 331 is like the weirdest, the most vague article, and it's something like abusing democratic rights to infringe on the interests of the state. So that to this day, I don't even understand what it means to abuse democratic rights to infringe on the interests of the state. But that's literally the language of that article. And because there's this legal framework to criminalize freedom of expression. That leads the government to arbitrarily detain writers and bloggers. There's no independent judiciary in Vietnam. There's really no way of appealing. There are lawyers, defense lawyers, human rights lawyers in Vietnam, but their numbers are very curtailed. They themselves are targeted. So that leads to arbitrary detention. And then, frankly, what's even more concerning, or even equally concerning, is the transnational repression, where it used to be Vietnamese living in Vietnam are targeted. Now it's Vietnamese living outside of Vietnam. And some of them are either residents or even citizens of the EU, or Vietnamese dissidents, refugees who have fled to Thailand, and they have been targeted. So there have been a couple of cases of Vietnamese bloggers abducted from in Thailand by Vietnamese intelligence, Vietnamese writers targeted in Germany, dissidents targeted in Germany. So that's the kind of another angle. So I would say, these are the factors that lead to the systemic repression or criminalizing of or the crimes against journalists. And so I wanted to touch on really quickly two case studies. The next slide, please. It's the story of Lê Đình Lượng. He is a renowned Vietnamese human rights defender, blogger, community organizer. And in 2016, he organized a lot of the protests around an environmental disaster and publicized it through his blogging. And as a result, he was arrested and sentenced to 20 years in prison for, quote, activities aimed at overthrowing the People's Administration. And fortunately, Media Defense took on his case, filed a petition, and we got a ruling from the working group that his arrest and detention was arbitrary. And it was a very strong ruling. I looked it up today. I hadn't read it, honestly, in probably a couple of months. And I was very impressed by the really clear reasoning in the opinion. And it talked about how he was exercising his fundamental rights. And I think decisions like this really lay the groundwork or the precedent for further advocacy, other human rights groups, media, journalists to raise these cases. So I think that was a breakthrough, especially when the authorities want to use such a strong statute to kind of demonize an activist. And so, so that helped a lot. But that said, he's been in prison since 2017. This summer, he was put in solitary confinement because he was protesting prison conditions, and visits by family were limited. And I want to note that his birthday is on December 10th, which is International Human Rights Day. And my organization, Viet has established a Human Rights Award in his honor that we announce every year. So one of the things that we need to do is to maintain the advocacy, the public awareness for this case. So this is a sort of a textbook case of someone who's arbitrarily detained. The next slide, we'll talk about, next slide, please. We'll talk about actually a very worrying trend of transnational repression and how this is evolving. So Vingroup is the largest conglomerate in Vietnam, and it's led by Phạm Nhật Vượng, who's the biggest oligarch in Vietnam, the first dollar billionaire in Vietnam, and someone who's very close to the regime. And his company has been criticized online for all sorts of things, of shoddy products and so forth. Some of it's true. I haven't followed it all, so I can't vouch for everything. But what I can say is that about less than 2 months ago, Vingroup sued 68 bloggers for defamation. And they didn't disclose the names of all these influencers, but some of them lived outside Vietnam and some probably are inside Vietnam. And what stands out are, he is an ally of General Tô Lâm, who's a head of the Communist Party. And in the announcement by Vingroup, they said that the defendants, that the Vingroup notified foreign embassies in Vietnam and Vietnamese embassies abroad about these cases. So, which was very strange, because if this was a private litigation of a company against private individuals, why does Vingroup have to notify foreign embassies in Vietnam and Vietnamese embassies abroad? And then thirdly, the defendants are all mostly, critics of the Vietnamese regime. And so, again, we don't know the names of all 68, but a number of them have been disclosed, and they're very prominent. So in Germany, it's Nguyễn Văn Đài, who was a human rights defender who was detained in Vietnam arbitrarily and then exiled to Germany. Lê Trung Khoa, who's one of the most well-known citizen journalists. Canada, Phương Ngô, Hoàng Dục, Phạm Minh Chính. So these are critics of the regime, and I think this is where we're seeing transnational repression evolve, and I think this is an opportunity to get involved. And I wanted to conclude with my last slide, which is really going back to the first slide and talking about some of the strategies we can do. So there's a state monopoly on media, and so frankly, we can support citizen journalists, so we can have a independent media. And we have government censorship of tech companies, and we have censorship that's done by the tech companies. So there's things that we can do to advocate with the tech companies, about their responsibilities, especially Meta and Google, or Meta and Alphabet are publicly owned companies with shareholders. There's a lot of things we can do there. And then we can also advocate on their behalf, because I think this is a trade issue when the Vietnamese authorities limit, frankly, American companies. And I think in this political climate, that might actually be one of the avenues for human rights advocacy. And then, criminalizing free expression, I think, challenging the three articles that I laid out, 109, 117, 331. And then arbitrary detention, I think we need to maximize the kind of the working group in arbitrary detention. We can talk about some strategies to do that. And when we have these decisions, we can, work closer with the UN special procedures to have follow-ups, to have prison visits. And frankly, I think the whole public advocacy is really important too, because these decisions are so powerful and we have to really publicize them. And then fifthly is the issue of transnational repression. What are the remedies there? Is there such thing as universal jurisdiction? So when Vietnamese intelligence abducts a person living in the EU, or targets refugees in Thailand, is that a crime? And in this Vin Group case, which I think is a kind of a modern, the latest incarnation of transnational repression, can we provide like pro bono help with some of the key cases like Nguyễn Văn Đài, who was sentenced in Vietnam, jailed, 2 or 3 times, exiled to Germany, now targeted again. So a few ideas, looking forward to the discussion. Thank you.
Thank you so much, Dan. I think that was really insightful. And even though the human rights record in Vietnam is not, and the situation of journalists there is really not good, I think it's good to see that Viet and other organizations have developed so many strategies to work against that and to hold perpetrators accountable. So I'm sure we'll have more time to speak about that later on as well, in more detail. But for now, I would like to turn to Furkat, who will speak to us about the European context. So Furkat, the floor is all yours.
Thank you, Wiebke. Good day, everyone. I would like to start by thanking the organizers for inviting me to participate in such a crucial and topical issue as the use of international human rights bodies to combat impunity for crimes against journalists. I would also like to make certain reservations as to the scope of my speech, because I'm not a national lawyer, so I maybe not the best place to comment on particular cases or strategic litigation strategies when it comes to particular cases. Also, I'm not an official of the Council of Europe, so everything that I will say about the Council of Europe is my personal opinion, and I invite public to complement and contribute on this. So I will mainly focus to describe the Council of Europe structure, how it is designed and how it can be used in bringing cases, in litigating cases and implementing cases concerning the crimes against journalists. And I would like to start by just mentioning that the Council of Europe overall mission is to protect and to promote human rights, democracy, and the rule of law in the Council of Europe member states. And it has a series of standard setting, monitoring, cooperation, and implementation bodies and mechanisms. So the main political body of the Council of Europe would be the Committee of Ministers, which focuses on both standard setting, creating the soft law standards in the Council of Europe, and also implementing the judgments of the European Court of Human Rights. To give you a couple of examples, the Committee of Ministers prepared a declaration and a recommendation on the protection of journalism and safety of journalists and other media actors in 2014 and 2016. There are also some special soft law texts that the Committee of Ministers published, such as the recommendation to member states how to counter SLAPS, which is the strategic lawsuits against public participation, or the guidelines on the responsible implementation of artificial intelligence systems in journalism. And also, of course, there are such relevant and topical recommendations such as the one on the need to strengthen the protection and promotion of civil society in Europe from 2018, and the earlier guidelines on eradicating impunity for serious human rights violations in the Council of Europe area. Then, in addition to the Committee of Ministers, we have the Parliamentary Assembly, which also creates soft law standards and has certain bodies that could be useful, in litigating cases relating to crimes against journalism. A series of resolutions concerning the threats to media freedom and journalist safety and security in Europe, dated from the last year, the years before, 2020, 17, and 15, just to cite some of them. Also, the PACE has a structure as a general rapporteur on the situation of human rights defenders and whistleblowers, which can also be extremely useful when you start thinking about bringing a strategic case to the Council of Europe human rights system. Another important body of the Council of Europe is the Commissioner for Human Rights, which is an independent, impartial, and non-judicial institution which is created to promote awareness and respect for human rights in Council of Europe member states. And the Commissioner mainly works on thematic areas and country work. And the third big section of the Commissioner's mandate relates to the cooperation with the European Court of Human Rights and the implementation process. So just to name a couple of examples of the Commissioner's thematic work relevant to the journalists, the safety of journalists would be a recent statement, this year's statement on the state's duty to protect journalists. Last year, the Commissioner issued another statement on the need to end impunity for crimes against journalists. There are also several human rights comments that the Commissioner published in the framework of its thematic work, such as the safety of journalists in conflict, the safety of journalists covering public demonstrations and protests, and of course the SLAPS, as I already mentioned. Then on country work again, this year the Commissioner focused on the safety of journalists in Georgia, in North Macedonia, in Azerbaijan. Last year, again on Azerbaijan, the Commissioner made many statements concerning the imprisonment of journalists. And now important element is the Commissioner work in cooperation and interaction with the European Court of Human Rights, and the Commissioner has the power to intervene as a third party in any proceedings that the Commissioner decide, and this is the specific feature because many other organizations may actually intervene as a third party, but they need to request the authorization of the President of the Chamber of the Court. And if the President of the Chamber decides to grant such a request, then an organization becomes a third party. The Commissioner has the autonomy to decide on which case he or she wants to intervene, which opens many good opportunities for national lawyers to reach out to the Commissioner and to try to convince the Commissioner that they have a very important and strategic case on which the Commissioner could intervene as third party. And since 2017, the Commissioner also has the power to participate in the implementation process, again by submitting Rule 9 submissions. And the Commissioner here again has a full autonomy to decide on which case to intervene. But of course, needless to say that if the Commissioner decides to intervene either in the proceedings before the European Court or in the implementation proceedings, I think the mere fact of intervention already signifies that the case is important and there are certain general issues at stake, because the Commissioner's mandate is mainly tackling the systemic structures and not working on individual cases. Then I would also like to mention the Council of Europe platform on the safety of journalists, which is also an important body which reports on media freedom and alerts on particular urgent cases, which could be used also as a protective mechanism. And probably lastly, I will mention Venice Commission, which can give experts' opinion on the specific legislation which is not in line with freedom of expression standards, and the HELP program, which is the human rights education for legal professionals, where you can have many free courses on various themes, more than 60 courses, including 2 on freedom of expression and the protection and safety of journalists. So all of those Council of Europe standards are publicly available, and they could be used by domestic lawyers, while preparing and litigating a case. On the European Court of Human Rights, obviously, we will discuss a little bit later when it comes to the strategies of bringing, strategic cases. And I would like to mention that, as I mentioned in the beginning, that the Committee of Ministers is the main political body of the Council of Europe, which is mandated to implement the judgments of the European Court. And according to Article 46.1 of the European Convention, member states have a legal obligation to abide fully, effectively, and promptly by the final judgments of the European Court, which means that they have the legal obligation to seize the violation, to provide reparations to a victim, and to provide guarantees of non-repetition. Now we have the specific feature is that the judgments of the European Court, they are legally binding, but the Committee of Ministers, which is responsible for supervising the implementation of those judgments, is a political body. So the implementation process of the legally binding judgments is entrusted to a political body, which has political instruments, which is a kind of paradigm and specific feature, and sometimes is a weakness of the Council of Europe system. Just to mention a couple of data to illustrate how the implementation goes overall in the Council of Europe. So once the judgment is delivered is not the end of the story. I would say it is just the beginning, in the sense that the judgment could remain theoretical paper without the proper implementation. And when it comes to implementation, according to the statistics, only 44% of leading judgments delivered over the last 10 years remain pending implementation, which is basically a half of the judgment. They remain unimplemented for over 10 years. And then the average time for implementing a judgment will be a bit more than 5 years, which is a long time in reality. But then it could be explained by several reasons, such as the weak national implementation structures, which have difficulties to coordinate the implementation process, the complexity of the problems identified by the European Court, or political reluctance, which is the biggest issue, and I will tackle this a little bit later. And lastly, I would like to just mention that the non-implementation or the late implementation of judgments affects the whole Council of Europe system. It creates the backlog at the Council of Ministers implementation process, which cannot in turn, to focus on truly complex problems. It also creates the backlog before the European Court of Human Rights, because similar cases keep coming to the European Court because the problem has not been solved at the national level. It also triggers the erosion of public trust and willingness for lawyers and civil society organizations to engage if they see that even if they win a case before the European Court, then nothing happens and reality remains the same. So there are serious problems and serious importance to focus on the implementation and to participate specifically from the civil society in the implementation process. So I would reiterate and my introductory overview here is that the implementation process very much and heavily rely on the state's political will. and the cooperation with the Council of Europe. And without the political will, unfortunately, many important judgments could remain abstract and bring no tangible effect on the ground.
Thank you so much, Furkat. This is a really comprehensive overview about kind of some of the instruments available to us within the Council of Europe system. And I think you highlighted a really important point here that we've heard from all speakers, which is that at the end of the day, even if a positive precedent is obtained without actual implementation, we don't see changes in the reality on the ground, both for that journalist whose case was litigated as well as for future cases. So I would really like to speak about that a little bit more later on. I would also like to draw people's attention to the chat. Some of the participants have highlighted other domestic contexts. I know we're just touching upon a few examples here. So I think people have spoken about Sudan and Gaza and Iraq and possibly other places. It's hard to keep track of everything that's happening, but I think there's some interesting contributions there as well. But I think for now, we'll just also move on to the kind of moderated discussion phase of our panel, and there will be more space for questions later. So we're collecting all of those. And yeah, I think those interventions from all of our speakers have really provided us with a good overview of the different risks that journalists are facing in different regions of the world. And due to the very different domestic and regional contexts, there's no one solution fits it all. But what we're hoping to is to facilitate dialogue and comparative strategies, collaborative strategies, and see if we can find aspects where we can introduce some peer-to-peer learning and find synergies. So to start off our discussion, I would like to take one step back, again, in an earlier stage of the life cycle of a case, and like Furkat mentioned, speak a bit about the litigation phase. So I would like to explore a bit further what are the challenges you're facing and the strategies you're employing when bringing cases concerning crimes against journalists to legal mechanisms. And maybe just to visualize this a little bit more, for maybe the non-lawyers in the room, cases concerning crimes against journalists, which we've also heard from our panelists, will often involve around the state's obligation to investigate such incidents and provide a prompt, independent, and effective investigation into the circumstances. And like Tsema mentioned, also the duty to protect from such attacks. And in other instances, there might even be credible information that crimes against journalists were carried out by state agents themselves, such as, for example, like Dan mentioned, in case of arbitrary detention, or in other instances, cases of enforced disappearances or killings. So I think it would be really interesting for all of us to hear from you again. And maybe we start with Carlos here about the practical and technical aspects and the difficulties and opportunities that you encounter when litigating such cases. Carlos, you talked a little bit about your work with the Human Rights Committee, and I think it would be really interesting to hear a bit more about that. You were talking a bit about the differences with the Inter-American Court of Human Rights and the Human Rights Committee, and I think also what these processes mean for the people on the ground, as well as their lawyers.
Thank you. First, I'm going to talk about the technique and how you make a strategy for litigation. I think first in Mexico we have a very hard and complex situation. Why? Because our local remedies are not effective. So when we design a case strategy, we need to go 2-3 paces after, no? Because why? In Mexico, we don't have a specialized judge about crimes against journalists. We have a special prosecutor's office, but the problem is they have a lot of cases, but they don't have a strategy. You know, they take case by case. They didn't identify criminal analysis or criminal finance patron or something like that. So in our experience, we have two kind of cases. The first kind of cases is the one of we have evidence that the authority commit the crime, no? like enforced disappearance or detentions, etc. And the second cases, it's like the Ramon Salpa, is we have an authority that received a complaint, but they didn't do nothing. So we are checking what he need to do, but we have a very big time with an inactivity. It's the kind of two cases. In one case, for example, in the Ramon, the cases when we have an ineffective authority, the strategy is what they have to do, and the other is we need to identify the intellectual authors, the complainants. Now, the second level is and it's one of the things that we choose the United Human Rights Committee. It's in Mexico. We have the first Inter-American system sentences in 2006, Caso Radilla. It was very impacting the society. But the problem is now all the human rights cases want to go to the Inter-American Court, and the court is full. We have America, it's a very big region, and we have a lot of human rights violations. But what we see is the Human Rights Committee, it's like it's not general, like the effects of the resolution of the Inter-American Court, but it's give a solution for the case, for the individual case. And what you asked me from advocacy and litigation, we want to reach both sides, because we want to tell a story about the case and visualize what is happening, because the journalist, the victim, it's a person who is in a human rights violation.
Yeah, thank you so much, Carlos. And I think this is something that I would also like to ask Furkat, because you've mentioned this in your presentation as well, which is the long duration that a case takes. Well, first, when it's litigated at the European Court, that's usually a process of several years. And then later on, the implementation phase, of course, adds more years, if even, you said earlier, 44% of cases stand implemented. This long duration obviously also can constitute an extra burden on applicants and possibly lead to re-traumatization and things like that. So I wanted to ask you, Furkat, do you, in your view, does the European Court of Human Rights still remain, and I think from your earlier presentation, I assume the answer is yes, a valuable instrument for the protection of the rights of journalists? And what are the strategies, the requirements, and maybe the challenges of litigating, of bringing such cases to the European Court?
Yes, thank you. Well, of course, my answer would be yes, but there are a lot of, specific features that needs to be taken into account. Generally speaking, of course, the European Court has its own priority policy. It's a kind of internal priority system of cases, and I believe that the attack crimes against journalists should be treated as priority cases. But it is very much on the lawyer, on the journalist representative to bring a proper case, to properly, focus on particular issues, to speak on the language on which the European Court functions, to clearly convey the main elements, and to clearly to bring the spotlight, the most important things which are relevant to the European Convention. Because on my previous experience, I had many cases which were poorly exhausted domestically, where the lawyers were focusing on wrong legal issues, focusing very much on the domestic. Well, I'm not saying they should not focus on the domestic procedural rules, obviously, but at the same time, from the very beginning, a lawyer or representative should be thinking about, the potential bringing case to the European Court and to raise the right questions before the domestic authorities. So that is the first thing. Then obviously I would say there are a lot of various different challenges to bring, a good strategic cases before the European Court of Human Rights. But I would like to focus again and to maybe say from my perspective of currently working in the European implementation network as not as a national lawyer, but more as international expert, is that I think that one of the biggest problem that we have is that many crimes remain underreported. And in this sense, the current case law of the European Court of Human Rights does not accurately reflect the magnitude of the problem, and therefore the implementation process as well focuses on particular judgments. And if there were a better preparation and litigation cases at the domestic level, we would probably have more relevant judgments from the European Court, and the implementation process would probably have different and more important aspects. And also by the very fact of having more judgments on a same problem could also trigger a certain reaction from the Committee of Ministers, for example, while treating a case either under the standard procedure or enhanced supervision procedure. And in this sense, the volume, the number of similar judgments is a relevant factor to take into account. Also, I think in many cases, journalists, they take, the intimidation and harassment and the crimes that they are faced as their normal daily reality. And in this sense, you have many journalists who do not report those crimes committed against them, or they have no capacity to reach those who can report, or those who can who have knowledge to properly tackle those issues. And in this sense, again, it is very important to network, not only by the mainstream civil society actors in the country, but to reach out to those, working in rural areas or tackling sensitive cases on which sometimes, there is low interest from other civil society actors. So in this sense, I think it is crucially important to improve the information communication channels and to connect, including, on one hand, among national actors, and on another hand, with international actors, including as with the European Implementation Network, as we have a capacity, to provide trainings, to raise awareness, and to help national lawyers and civil society actors how to properly prepare a case, litigate case, and then how to properly, take it through the implementation process.
Thank you, Furkat. And I think you mentioned a really interesting aspect of the interconnectedness of different mechanisms and how, for example, the case volume on a certain topic might then affect implementation of other judgments as well. Because you mentioned a topic that I know is very different in the ECOWAS court, which is the exhaustion of domestic remedies, I would like to move back to Tsema and ask you about your litigation experience, or generally the experience in litigation, litigating cases concerning crimes against journalists at the ECOWAS court, that currently, at least as a regional court, functions a bit differently from other regional courts.
Yeah. Thanks, Wiebke, and thank you everybody for your intervention. It's been interesting learning from you. So the ECOWAS Court for Community of ECOWAS Court on Community Court of Justice is focused on issues that concern human rights and related matters within the ECOWAS region. Those are countries in West Africa that are covered by ECOWAS. And there are specific requirements and significant challenges and important opportunities that dealing with the ECOWAS Court presents. But ultimately, the ECOWAS Court has contributed excessively and extensively to human rights protection in the region. And so what are the main requirements for the ECOWAS court litigation? Jurisdiction. The CCJ has jurisdiction to hear cases alleging human rights violations in a member state. and including those concerning crimes against journalists, for sure. Violations on the right to life, freedom of expression, freedom of movement, and the prohibition of torture. All of that come under the kind of violations that we can present before the ECOWAS court. He also has broad standing rules, which allows individuals, including their journalists, their families, and victims of abuse, corporate bodies to bring an action before it. A lot of times, even within the region, we've seen cases of where the state has brought like objections to certain people bringing in cases, especially when it comes to internet reviews and access. And they say journalists don't have the right to internet, and the court always speaks on even their right to earning a living and how that is important. And so the ECOWAS Court of Justice has been very, very extensive and has helped us define human rights more broadly to protect journalists. And it has broad standing rules as well. So anybody can bring a case before them, a journalist, his family, victims of abuse, corporate bodies, they can all bring it. And even organizations, NGOs and other organizations can also apply to intervene as amicus curiae. So they can come before the court. And I think Media Defense has done that a couple of times, and has supported a few other lawyers to go and present themselves as amicus in cases where journalists' rights have been violated and in the ECOWAS court. And applications cannot be anonymous. So applications cannot be anonymous. The same matter cannot be pending for another international court. So that's another thing. So for a case to be admissible, it shouldn't be pending in another international court. And what makes us, like Wiebke said, what makes it so important is that you don't have to exhaust domestic remedies before you come to the ECOWAS court. And so even with the case on the Twitter ban, the case on Nigeria's Cyber Crimes Act, and how, we was going through such a long process within the national court system, it was so important that the ECOWAS court made a quick judgment with regards to the Twitter ban in Nigeria and some other provisions of Nigeria's cyber crimes law that was being used again to violate the rights of journalists. But like you said, Furkat, there are also challenges with litigating cases before the ECOWAS court. And we also have the same challenge within the region, gathering evidence. Sometimes gathering evidence can be so difficult to prove that the state did not fulfill those obligations. And because you need comprehensive evidence to prove the alleged violations. Because where a state fails to investigate, prosecute, and punish perpetrators, that's the due diligence conversation, the due diligence obligation. It's very important that those of us who are bringing cases before it are able to prove that extensively. And that's what Data Haidara helped us to prove. The Haidara case showed that where this journalist was assassinated and the state did not do anything about it, that the state fulfilled in its obligation. And to what Wiebke said in the beginning of this seminar, that always creates a chilling effect. And I think several times the ECOWAS courts, the African Commission and African courts have used that same phrase, talking about the chilling effect where states fail to fulfill their obligation. And so the challenges to litigating in the ECOWAS courts is the enforcement of judgments. That has been a big problem because most often the ECOWAS court, I don't even want to call it a big problem because I think what I've noticed over time, and I stand to be corrected, is that once a judgment has been made by the court, very rarely do you see other judges trying to deviate from the judgment of the ECOWAS court. Other judges will not say, no, the ECOWAS court was wrong in its judgment. But the problem with it is the high non-compliance rate by member states. Because the court lacks an independent mechanism to monitor and enforce its decisions, it relies on member states to execute it basically in good faith, right? Through their national authorities. You find that there is no mechanism that ensures that the ECOWAS court's judgments are followed through. So most often the court will recommend that a state does better in how it addresses human rights violations. Most times it will give a judgment on cash compensation. I know of a case of someone whose rights were violated in Nigeria, and the court had asked Nigeria to pay a certain fine. At last time I spoke to her, she hadn't received the fine. So those are the kind of problems that we face with regards to compliance of those judgments and its enforcement. So the due diligence deficiency, like I spoke about, it's always a lack of the ability to prosecute that very well, where you're unable to get evidence. But now what we found, states have now found a way to navigate that now is with their repressive laws. Like I said earlier, there are fake news, defamation, sedition, and cyber crimes laws. And they use that to weaponize it to intimidate critical voices. And this unfortunately leads to self-censorship. But what I have also noticed with the ECOWAS court is that when those kind of cases are brought before the ECOWAS court also does the legitimacy test, proportionality test, and necessity test. And so how necessary is that law? That law that was prescribed, is that law done in good faith? And what else can be done? What else can be done to protect rights? So again, it's like it's almost like a whack-a-mole when it comes to, I call it like a whack-a-mole, because almost like once you you decide that this is where a state is violating human rights, or this is where a state fails in its obligations to protect, prevent, punish, and investigate, they find a new law, or they find a new way to go around that. And that's what we've been facing over time. And so also cost is a problem. It's very expensive. Litigation, as we all know, wherever we are, is a lengthy and expensive process. And oftentimes you find that the victims of this violence and their families get exhausted because they have no support, which is where non-profits come in, NGOs, and some of us with the work that we do come into play. Because what we do is we provide them with the kind of financial support today. That's why everybody's job is important, right? You give them the kind of financial support they need for them to continue with those cases to the end. And it's imperative that they complete those cases because those judgments set a precedent, right? And so we ensure that states do not go about disobeying laws, because states are willing to, we can never compete with states when it comes to spending money. They will go dollar to dollar, kobo to kobo, cent to cent, whatever it is, they will really go against you with the cash. But we must, as citizens, stay on course, and whatever we must do to support journalists or whoever it is representing journalists, especially with the litigation process, is very important, because the court, even though the court is accessible, like I can speak for the ECOWAS court, it's very accessible, but there's a general lack of awareness and financial means to litigate some of these cases. And even you need specialized legal representation, people who are familiar with the ECOWAS court processes. For in Nigeria, for instance, you have to translate your process in English. In Africa, in ECOWAS rather, you translate in English, Portuguese, and I think Portuguese and French, the official languages of the ECOWAS. And so all of that gets people exhausted. We now find a translator and make sure everything is done properly. And there's a number of copies of everything you have to make. So those are the kind of things that come with litigating at the ECOWAS courts. But there are also security risks. Litigating sensitive cases sometimes expose journalists and their sources and their families, and even their legal representatives, their lawyers who have faced threats because they're representing journalists, further threats, intimidation, and physical risk. But I will always say that we need to stay on course because we need to stand for justice. Otherwise, these guys are just going to continue to thrive. And if there's no consequence for bad behavior, impunity will continue to fester. And so there has to be continuous consequence for bad behavior. When we are doing ECOWAS cases, name and shame, we use these cases, we use this strategic litigation to make sure that whatever it is we need to do gets the kind of impact it gets. So even if states may not comply, there's a judgment that exists. If there's a judgment that exists, we can continue advocacy around ensuring states comply, ensuring that states comply with the the judgment of the ECOWAS court. That is what we try to do in most cases. And I just want to end with opportunities for impact, because there are opportunities for us to continue impact. Because there's no exhaustion of local remedies, it's very easy for us to just go straight to the ECOWAS. It's a fast track mechanism, and it has provided groundbreaking judgments that has changed the way we perceive law in Africa. For instance, like I talked about the Data Haidara case, where the court ruled that the state's failure to investigate the murder of Data Haidara was a problem, and it ordered the repeal of criminal libel and sedition laws. And Nigeria, the unlawful suspension of Twitter. The ECOWAS court judgment was so critical to how we engage on internet freedom and freedom of expression within the region, and that's changed the course of our engagement with the online community and our digital rights, so to speak. And also, the ECOWAS court can issue interim measures to protect journalists facing imminent harm, and so it's also as urging a state to ensure the security of an endangered individual. And we try to use all of these opportunities that we get. We try to use everything, the lower hanging fruits. But I also want to speak about the importance of advocacy, because that is how we deal with impunity. And that is how the ECOWAS court has contributed to dealing with impunity, because it affirms the state's duty to investigate. It has explicitly ruled that the state is required to conduct a thorough, rigorous, and independent investigation into violent crimes against journalists. It also held that the state's failure to act on these crimes is in itself a violation of its treaty obligation. And the court also recognizes the systemic impact. That's what I talked about, the chilling effect on press freedom. And it has provided a safe forum for individuals to engage with the legal system and the judiciary to ensure the protection of journalists' rights. And it sets a binding precedent. So the ruling sets a binding legal precedent that any ECOWAS member state can be held directly accountable for if they fail to protect journalists, for not, so to speak. And so that is how the ECOWAS court has even contributed to dealing with impunity. And so often I'm like, oh no, it's soft law. So in fact, I've heard people say it's a soft law, it really has no binding effect, so there's really nothing you can do. But it's important. States do not comply, yes, But are there ways we can get them to engage with the system? Yes. Are those judgments binding? Yes. And to other states, other member states of the region have an obligation to ensure that they respect and obey the judgments of the ECOWAS court. Yes, they do. And so I would say that there are more wins than there are losses when it comes to engaging with regional systems. And I know people get tired, especially because of impunity and how they feel like, well, I'm never going to get justice. But I think it's important that we constantly remind ourselves that they will get justice and we have to stay on it. If we do not stay on it, I will always say this, there has to be consequence for bad behavior. If there's no consequence for bad behavior, whether it is naming and shaming, whether it is even just getting them to pay a fine, whether it's getting their colleagues to hold them accountable, something has to be done. And we can't just sweep it under the carpet. Otherwise, the carpet is going to get too full and we won't be able to stand on it anymore. And it's ultimately a threat to democracy and human rights. Thank you.
Thank you so much, Tsema. Apologies, I'm a little bit sick. Thank you so much. And I think this is a shared sentiment that's really come out in this webinar so far, that even though litigation is often difficult and a lengthy process, and then implementation remains a whole separate challenge, which I want to touch on very quickly as well. So running short on time, as in every webinar. I think you really stressed, and all of you have really stressed, that should not deter us from continuing this important work. And I think just moving back to you, Dan, I think the Vietnamese context obviously is very, very specific, and also what you say will apply to loads of other people who've shared their experiences in the chat or have asked questions about this, which is, well, what do you really do when there's no regional court available to you, and where you can't even go to the Human Rights Committee because, well, the optional protocol 1 wasn't ratified. So what then? And you've talked to us about the possibility of going to the UN Working Group on arbitrary detention and the sharp language that's used by the working group. I do think that in the case example you mentioned, the journalist remains in detention. So the question is, well, what's the added value of bringing cases to these mechanisms? And also, what can we as civil society do to, and again, you've touched a little bit upon this already, but what can we do to push for the implementation and push for change?
No, that's a very good question. And, you know, the families of political prisoners really appreciate the outside, intervention, the support for the international community. But when we work with the families to raise a case, the first question they have is like, will it actually help? Is it worth the risk to the families? Because the authorities actually will retaliate against the families as well. And sometimes there's a fear of like, is it better to just do things on a very low profile, and hopefully something will resolve itself, or should they actually lodge a case? So that question, I think, is first of all a question that families of political prisoners have, and they have to weigh the cost benefit. And then secondly, is when these cases or these opinions come out, sometimes it takes a couple months for the working group, or even like 6 months to a year, and they kind of publish it, but it's like if a tree falls in the forest and no one's there, I mean, does it really make a sound? So it's really up to us to really publicize these rulings and draw out like what are the takeaways? Why is it significant? What does it matter? And I think in some of the cases, we've all done a good job. Others, I think we have not done a good job in terms of like publicizing the decisions, and that's kind of a waste. And then I think, the third thing is, okay, so there is the decision. This gets to the heart of your question, Wiebke, is, how can it be implemented? And there I would say that I think we have to, I don't know, how much power the UN or the special procedures have, but I think they do have some, especially when states such as Vietnam are members of the UN Human Rights Council. We should leverage that to get these special procedures to go to Vietnam, visit these individuals in jail who have already been ruled to be arbitrarily detained, and check on their prison conditions. So I think we need to do a little bit more follow-up when there are decisions. But I'll take a step back, and although sometimes it's kind of like infuriating that there's not enough of a follow-up, but I think ultimately these decisions matter a lot, because the Vietnamese authorities, and I think a lot of dictatorships, will say that they have no political prisoners. Everyone is arrested for being lawbreakers, for violating the law. And I think these international rulings establish that these individuals were just exercising their basic rights under international covenants, which the state of Vietnam is a signatory to. And I think that legal and moral force in the long run is extremely important. So although I would love to see much more implementation, much more follow-up, I think just establishing the principle that these individuals are arbitrarily detained, that in itself, I think is very important to underscore that these are political prisoners, prisoners of conscience.
Yeah, thank you so much, Dan. And unfortunately, I'll have to ask you to, like everyone else, I will ask questions to limit your answers to maybe a minute or so, because we have a lot of questions in the chat. But before we just move on to that, I quickly want to essentially pass Dan's question also to you, Carlos, because obviously you work with the Human Rights Committee. You said the cases or the case examples you've given us, they're still in quite early stages, but I still do want to ask you about implementation of Human Rights Committee views or decisions. So I know there's a follow-up process. Is that something that has proven in your experience or just from general knowledge is useful in the past, or are there other strategies that Propuesta Cívica and others engage in to implement those opinions?
Yes, in case of the Human Rights Committee, for us is it's not a easy procedure, but it's not full like the Inter-American human rights system. What we see is when you start a special communication, when you present a communication, the state have to receive the communication from the Human Rights Committee, and they give you time for the answer. They after to give you the reply. You can say things about the reply, more evidence, or things like that. Then the committee close the instruction process, we can call it that, and start to study all the communication. What we see, it's an easier process. They have the same structure like the Inter-American system, but we don't have the Inter-American Commission. You have direct communication with the community. It's better, no? Because in Inter-American human rights system, you have to go first with the commission. Then, if the commission want to send the case to the court, and there are 20 years that we don't want to take. Why? Because the victims are sometimes the family of the journalist. They are older people. They start with childs, and now they are an adults. So what we want is a faster procedure, and we think the committee have both things. It's a legal and jurisdictional process. It's part of the United Nations treaty bodies. It's okay. And when the United Nations talk with the state have the pressure. They want to be cool with the international community. We are defend all the human rights, but the problem is we have to make both things, work in local remedies and do the commit. And what is better about the commit is the commit look more cases. In one visit, in a local visit, they can see, I don't know, 14 cases. The International Human Rights Court only watch 1, 2, 3 audience hearings in their visitings. So we prefer the commit for that reasons. And maybe they don't have the same effects like an Inter-American resolution. You can make an unconstitutional law and norm with the court, but the committee it's a remedy for the people, for the case, and you have the resolution to to go to the government and say, hey, help me, or do it. That's our reasons.
Thank you so much, Carlos. I have a lot more questions for all of you, but I think it's time for us to move on to the kind of Q&A. And the first question is for you, Furkat. So it's actually, I have two questions for you. The first one would be, what is the best way for civil society organizations to share information on specific cases of journalists with the Council of Europe Commissioner for Human Rights? And then I think it would also be interesting if you could tell us a bit more also about how civil society can engage with the Committee of Ministers on implementation of specific judgments.
Sure. Yeah, so answering the first question, luckily, the Council of Europe Commissioner's Office is not as formal as the court, as the European Court of Human Rights, so there is no admissibility procedure or some filtering. I would suggest that you can just simply Google the coordinates of the Commissioner's Office online. You will find them, and send a concise message informing that you have very much relevant information concerning the cases on journalists in the Council of Europe area. I would suggest that your message should not be more than a half a page maximum, with a short description of the problem and the information that you have. There is no need to try to convince the commissioner about the problem. They are very much, I mean, the office of the commissioner, very much aware of basically of all of the problems that happening in Council of Europe area, because they have a team of advisors, not legal, just team of advisors who monitor the situation on a daily basis. So no need to, to explain them and to convince them. You just need to describe the problem. And if the issue falls within the mandate of the commissioner, and I assume it would fall if there is a problem with the journalist's activity, then one of the advisors would reach you, get back to you, and request additional information and evidence to your allegations. So it's quite simple. Then, concerning the civil society role in the implementation process, I think this is very much important, and it derives from what I said earlier, is that the state remains free to choose means how to implement the judgments, in the sense that the government reads the judgment, understands it on their own, subjective sometimes understanding, and then provide action plans where the government basically puts the information how they intend to implement the judgment. Of course, civil society may have alternative views how things should be done, about the scope of the implementation, about the way of the implementation, and civil society can and should, I would say, participate in this implementation process to counterbalance the information provided by the government. This can be done in a form of Rule 9 submission. Mainly information about the action plans is available online. Again, if you Google on the QDoc exec database of the Committee of Ministers, you will find your case you are interested in, and then you can see what has been provided by the government. There is a certain timeline. There is 4 quarterly meetings of the Committee of Ministers devoted to the implementation of judgments. It is also available online, so I would suggest that you take into account what is happening, what is being scheduled for those meetings, and of course, in these Rule 9 submissions, you can provide information about the general measures, and if you are representative of the victim, then you can also provide information about the individual measures. European Implementation Network focuses particularly on the issue of helping civil society organizations and lawyers to effectively participate in the implementation process. You can reach us, and we will be happy to look at your case or to accompany you with legal expertise, with advice, and with information sharing.
Thank you so much, Furkat. This is really helpful. And I think initiatives like the European Implementation Network really help streamline processes there, especially where lawyers or civil society are not a specialist in those submissions. So that's a really great opportunity. I have a question for everyone. So just feel free to jump in. This comes from a journalist who was previously themselves imprisoned in Russia and now works on advocacy for journalists, who asked, how important is public advocacy for journalists in their cases, especially given the risks they face by speaking out publicly? Like how is the situation in your respective countries or in Furkat's case, region?
I think over here, advocacy is very important. Dan? Okay.
No, I would say it's absolutely important. That's it.
Yeah, it's very important. I just want to tell like 3 stories of journalists who have been freed because of advocacy, and it's a make noise kind of situation. The advocacy is make loud campaigns, make a lot of noise, and partnership with other journalists. I think that what happened with Martin Ezongo's story, I like what happened when Martin Ezongo was killed in Cameroon, and the fact that journalists from across the world came and finished his story. So he was killed because he was exposing corruption in Cameroon, and they didn't want his story to die. So there was a Dutch journalist, a journalist from everywhere around the world, and they came and they finished the story. In Nigeria, we've repeatedly seen that advocacy come to play in the freedom of journalists, in naming and shaming them. And so, yes, advocacy is critical. It's very, very critical. Everyone is a partner. I would say to journalists and lawyers, every group is a partner. Even the local markets women association they are good partners to have. Local community groups are good partners to have with the advocacy. Just make sure that everybody they have something at stake. Show them how it benefits them. Show them how it affects them. How these journalists suffering, this violation that this journalist experiences, bring it home to them, make it relatable. And if they're able to relate with this story, that is our job. Then you get as many people. So even the person sitting down is asking his father, a child in university is asking his father, who's a government official, why are you arresting this person for telling a story, until they're embarrassed enough, especially for those of us from countries where with rule of law, sometimes it's just a recommendation, it's just in the books. There are other ways you have to engage. And that's why I would really recommend advocacy to far and wide and across borders.
Thank you so much, Tsema. Does anyone else want to answer this question? We have a couple more, so we can also just...
Yes, I will just comment a little bit. I would differentiate, honestly speaking, about the safety of individual journalists at risk, if this is the case, from the creating a safe and enabling environment, generally speaking. Because on my previous experience, sometimes advocacy behind the scene could bring more effect on particular cases, again, where I'm speaking about very specific situations where there is a real risk of safety of a journalist. But overall, of course, if we speak about adopting general measures, bringing real changes, combating impunity, and changing the overall situation, obviously they must be coordinated and very well holistic approach towards advocacy at different levels, at the European level, at national and regional levels.
Thank you, Furkat. I think this also really ties in with what Carlos said in the beginning about tackling different levels, so national, international. Another question that we've received in the chat is for Tsema. If you're... So I can't see a video right now, but I think you're here, right, Tsema?
I am.
Yeah.
That was an accidental. I didn't know my video was
It's all good.
Yeah.
So
what's the question, please?
It's a question specifically about a case you mentioned, which is the Hidara case.
Oh, yeah.
And they're asking, so there was a conviction of one of the perpetrators in Germany under the legal principle of universal jurisdiction. And the question is, the ECHO's decision preceded that criminal conviction. So in your opinion, or to your knowledge, to what extent did the ECHO's decision lay a pathway to this and other measures of justice?
I would say that the first way thank you, Wiebke. I would say the first way the ECHO's decision laid a pathway is when the judgment said that, when the judgment of the ECHO's court stating that the state had failed in its duty of protection and investigation, the explicit ruling of the court at that time made it clear that there was a judicial pronouncement on state action impunity. And they said that that is not a way to go. The ruling served as international proof that where a state is unwilling and unable to prosecute, then maybe that is a primary condition required to justify the application of universal jurisdiction by an external country. It also goes on to talk about creation of political and advocacy leverage. It's very important that we understand that because this judgment had existed, now we have human rights organizations being able to mobilize international pressure to say that this is a problem. And since there's a conviction and there's a judgment, not necessarily a conviction, but since there's a judgment in a regional level, then yes, states have a mandate to go to so and so and so with regards to this case. And I think that was the role that the IDARA case fulfilled. Finally, I also say that it also provided the evidentiary groundwork, as you were very well known. We talked about how gathering evidence can be a bit of a challenge and how sometimes it's difficult for people to gain judgments in ECOWAS courts because of all of that, because of the gathering of evidence. And so I believe that the fact that evidentiary groundwork had been done on the IDARA case, it was easier for us to be able to gather the evidence. It was for justice to be served in that case and ensuring that universal jurisdiction happened and that Germany, and there was a successful investigation and prosecution in Germany with regards to that conviction that happened. So yeah, I will say that yes, it was a trigger. It was a judicial trigger, and I agree with you. It was a judicial trigger for global action, and it validated whatever was going to be brought forward at the international courts outside of the ECOWAS region. So thank you for that question.
Thank you so much.
I hope your question was answered still.
Well, thank you so much, Tsema, and thank you to all of you. Unfortunately, as always happens with webinars, we ran out of time way too quickly. We still have a lot of questions in the chats. So if you have a chance to reply to those directly via the chat function, that's amazing. It always happens. But it tells us how important this topic is and how much people can take away from this webinar and the strategies and experiences that you've shared. So thank you all for attending our webinar. In particular, a huge thank you to our panelists, as I said, for sharing your insights, strategies, expertise, and for answering all the questions. It was wonderful to have you all. And please keep an eye out for our next webinar. We'll announce it via our newsletter. And yeah, I hope you have a wonderful rest of the day and hopefully see you all soon.
Thank you, Wiebke. Bye, everyone.
Thank you.
Bye-bye.
Goodbye.